Did you listen to that recording?
I did.
Okay, so if I play the recording of the phone call between Mr. Foncham and Pat, would you recognize that? Would hear that recording?
Yes.
Yeah,
Okay.
I would again object to that, again, lack of personal knowledge.
Okay, how would she have personal knowledge about that, recognizing that phone call?
Because she said she listened to that. Did you listen to the phone call terminate what allegedly terminating Mr. Foncham employment with MSU?
My boss sent me all the recordings.
Okay, and you had time to listen to that?
Get to the police.
Okay, you listen to the recording?
Of that one, I just heard it today before the court.
So if you listen to that now, you will recognize that this is a recording, the conversation between Mr. Foncham and.
But Your Honor, she would have no way to know when it was reported or how it was reported.
Your question was, did she know that he had been terminated?
Because in that conversation, she said no, and I want to listen. I want to give her the opportunity to refresh her memory, because she said that she was told when he was terminated.
Oh, because she couldn't remember when he was terminated. She said the recording. Okay, well then he's not. You don't need to play that for the court to hear. She's supposed to get that to find out when he was. Because that's important. We do need to know when.
Yes, Your Honor.
I'll allow you to refresh your recollection. I wasn't sure why you were offering the video.
May I have a question, sir?
Yes.
Can I play that so that she can refresh her memory? I'm not.
Oh yeah, you can play it for her. That's
Okay,
fine.
thank you.
Yeah, I'm fine. I missed the call. Yeah. Stop your assignment at state, doesn't state, not go back in. Okay, all right. And we'll get in touch with you as far as recommendation, what we need for you to get something cleared up on your background. Is that a problem? Yeah, there's something popped up on your background. Oh, okay. I'm sorry. Where was I? Where was I? I'm not really in charge of that. I'm just sort of helping out here today. But you want to come in this afternoon? We can work it out. Say around 1 o'clock. Oh, okay. You come in our office here at 1 o'clock. Oh, okay. Okay. And do me a favor. Not go back. Yeah, I'm not going back there. Okay. All right. My schedule was tomorrow, so I'm not going today. I'm not going back. Okay, so you won't be going back at all. But we'll yeah. When we're cleared up, we'll have to write out what we need to do here this afternoon. Be here at 1 o'clock and I'll know. Oh, okay. All right. Yeah. All right. Thank you.
Have you been able to refresh your memory?
Yes, but I still wasn't there for the call. I don't know if that's discrimination call or if that was just when he called.
Can you let me ask the question, please? Okay, so from this phone call, it looks like Pat asked Mr. Foncham, it was on the 25th, correct?
Your Honor, I'm gonna object. There's nothing in the phone call that gave a date or time.
Okay.
What?
It doesn't give a date and time, I'm assuming. Did it refresh your recollection? That's the date and time? No, not for the date and time.
You told the police that Mr. Foncham was going to come back at 1 o'clock that day. Is that correct?
I did.
So, and Pat today Pat on that phone is also asking Mr. Foncham to show up on that day at 1 o'clock. Is that correct?
Yes.
Is it fair to say that at the time that the phone call was made, that from this phone call with between Pat and Mr. Foncham, he had not been terminated yet?
I have no idea. On that.
When Pat asked him to come to you testified earlier that sometimes you have people come to the office to give them the opportunity to, especially if they're going to appeal the case, correct?
Yeah.
And so is it fair to assume that Pat was asking Mr. Foncham to come to the office to sign the paperwork to be terminated? Is it fair to assume that Mr. Foncham was given the opportunity to come to the office to fill out the paperwork?
Yes.
Yeah. And that day was that was the same day that you called the police.
Yes.
And so from this phone call, Mr. Foncham was going to come back to the office to be terminated, correct?
No, he was already terminated.
Okay. How do you know?
Because Pat told me that he was terminated and he was coming to the office and I was asked to leave, which is what I did after I was done with the case.
In this phone call, Mr. Foncham doesn't seem to be threatening anyone. Is that correct?
Yeah.
He's asking Pat why there is a suspension of his employment. Is that correct?
He's asking him what?
Why his assignment is being suspended?
I did not hear that part.
Would you want me to?
Sure.
Okay. What is this? Pat? Yeah, I have a call. Yeah. Hey, yeah, we need to stop your assignment at, state doesn't stay, not go back in. Okay, all right, and, we'll get in touch with you as far as, recommendation, what we need for you to get something cleared up on your background. Is there any problem? Yeah, there's some pop up on your background. Okay, no problem. What was that? I'm not really in charge of that. I'm just sort of helping out here today, but you want to come in this afternoon and we can work it out, say around 1 o'clock? Oh, okay. At 1 o'clock. Oh, okay. And do me a favor, not go back to this. Yeah, I'm not going back there. Okay. All right. My schedule was tomorrow, so I'm not working there today. I'm not going back.
Thank
Okay,
you.
so you won't be going back, you know?
On the 25th, Pat asked him to come at 1 o'clock
Yes.
at the office, correct? And you received the phone call at 7:27 in the morning. Is that correct?
Somewhere around there, yeah.
Now, if the because if you talk to the police that day, if I show you the police report, would that refresh your memory on what time you said the phone call arrived?
Probably.
Yeah, for sure.
That's
So is the time that you told the police that the voicemail was left had been refreshed by this police report?
If that's what I said, that's when the time said that the voicemail came in, yeah,
And so, it was 7:38 in the morning.
I believe so.
You did not talk to Mr. Poncham regarding any problem at MSU, is that correct?
I do not believe so.
You did not tell him anything about his background.
I do not believe so.
Mr. Poncham did not tell you that he's going to come back at the business at 2 o'clock, is that correct?
Say that again.
You did not, actually, you did not talk to him that day.
No.
Did you tell the police that Mr. Poncham told you that he was going to come back at 1 o'clock that afternoon?
That's what he had told Catherine. I told the police that that was what was stated, yeah.
So you told the police that Pat told you that Mr. Poncham is going to come back at 1 o'clock that day.
Correct.
And that day was the 25th.
Yes,
Which is the day that the phone call was, the threats were made.
yes,
Now, you say you were afraid. And it's okay, it's normal that after that kind of phone call, you be afraid. When you say, you told the police that Mr. Poncham is coming back at 1 o'clock, you did not you did not ask the police to stop him from coming, is that correct?
I did not.
You did not ask Mr. Poncham, you did not tell the police that you're too scared for having him come in the office, is that correct?
No, I did tell the police that.
Or you
That's
did
why I
not,
was asked to leave.
okay, you left the other people for this quote unquote dangerous person come to the office, is that correct?
I did.
And to the best of your knowledge, when Mr. Poncham came to the office, he did not, oh, well, actually, let's back up. He came earlier at the office, correct? Around 10:30.
The doors were locked.
Okay, so you because you called the police that he's been back in the office, is that correct?
I did.
No, you didn't see him talk to Pat,
See who talked to that.
Mr. Poncham.
That's my recollection.
Okay, so you were not there when Pat told him to come back at 1 o'clock, that the appointment was at 1 o'clock, is that correct?
It was my understanding that Pat went outside to talk to him. He was never, nobody was allowed in the office after the threat.
Okay, so Pat went outside and talked to him.
He did.
Okay. And to the best of your knowledge, he was asked to come back at 1 o'clock.
Correct.
And he came back at 1 o'clock.
I was not.
You were not there, but did you hear that he came back at 1 o'clock?
Objection, Your Honor. Yes, sir.
So the
Let me
objection
rephrase.
sustained. Thank you.
When you came back after not being there during his meeting, nobody had been shot. There was no shooting at the office. Correct? We did not know that. Nobody has been hurt.
Right.
You did not hear from anyone, though there was no conversation about him having threatened anyone at that time, correct?
Not that I know.
When on the phone call between Pat, you did not hear Pat or nobody in the office communicate to him that MSU employees were kind of scared of him. Is that correct?
Objection, Your Honor. Lack of personal knowledge.
The question was that she didn't,
From the conversation with Pat, there was
okay,
no,
yeah, the objection sustained. Thank you.
from the phone call, there was no, okay, you did not tell him that MSU the MSU employees are afraid of him because of his behavior, correct?
I do not remember.
Okay, you don't know if Pat told him that,
I was under the impression he did, but I don't know.
okay? You hear the phone call between Pat and Mr. Poncham, and I'm sorry, I don't know Pat's last name, but you did not hear from that conversation that it was conveyed to him that MSU people are afraid of him, correct?
Objection, Your Honor. Yes, sir.
Objection sustained.
told the police that it was because of his accent that you, and the circumstances, what his accent, that in circumstances of his suspension or termination, that you believe that it was Mr. Funcha, correct?
Yeah.
Now, you have other people from, you have, being a tech agency, I suppose that there are a lot of people from different countries, like correct?
Yes.
And you had the opportunity to talk to people from Africa.
Yeah.
And you had the opportunity to talk to people from different part of Africa, correct?
Yeah.
Okay. Now, you told the police that he was from West Africa.
I don't think that's what I said. I would have no knowledge of where he's actually from.
Okay, that it was his accent from West Africa. You report telling the police.
I did say it was a heavy, I did say it was a heavy accent.
If I give you the phone, if I give you, so that your recollection is that it was a heavy accent.
Yes.
And you do understand that a lot of people have heavy accents.
Yes.
And so that you cannot really it would be difficult for someone to decide based on someone's heavy accent where he comes from. Is that correct?
Well, with all due respect, Divine was the only one that I have employed with that accent. At that
Really?
time.
Really? You testified earlier that you had a lot of people from Africa.
Not that we're employed, he was placed at an employment, I hadn't had anybody placed at that time, accent at all, no accent at all.
No accent.
He was the only one.
Okay. So is your testimony today that the only accent that you could recognize was the accent from Mr. Concha? So you have never dealt with other people coming from Africa?
I have, he was just the only one employed with us at that time with an accent,
Okay.
any type of accent.
Okay. Now you did not check his phone to see whether or not the phone. Actually, you told the police where that the area code where that phone call was coming from, correct?
Yes.
And it was not a 517. It was not the area code for Mr. Foncha because
It's the one we have for him. Each of our employees are stored in our database so that when they call and the phone lines are busy, we can be sure to get to them first.
okay. And what was that phone call? What was the number that you have for Mr. Foncha?
I cannot recall.
Okay.
The one that was in the video.
In the video. I'm going to show you again the transcript for the voicemail. It has the voicemail from the police, correct? Yeah, for sure.
Yes.
Yeah, that's a private number. When somebody calls private on our phone line, that's how it shows up.
Well, you just testified that it was Mr. Foncham's voice, phone call,
I think I got
telephone.
confused. I think we're talking about the one with Patrick still.
Well, you will have no reason to know what. Okay, so the voicemail that you hear that day did not have was not coming from Mr. Foncham's phone.
Oh, no.
I have no further questions, Your Honor.
Redirect.
Thank you, Your Honor. Start kind of where Ms. Wanji left off and talking about the phone number that came through on the voicemail. Can you explain what you meant by that was when somebody calls private, that's what shows up?
Yeah, so we have on our phone system, it's not like a landline phone that you would have, it's an internet-based phone system. And when people call private, it shows up with a series of sixes, I believe. And that just means that somebody called private, so there's no way for us to know who that was.
And when you say call private, does that mean like a star 67?
So back in our day, that's how we did it, but I don't know if that's how it still works.
Okay. Fair to say that when they call to try to block their number from a caller ID, your internet phone provider will provide that star to the sixes.
Correct.
Okay, and that's how you know it's a private
Correct.
call. Okay. And did you ever try to identify the origin of Mr. Fanshawe's accident to law enforcement?
I do not believe so.
So when Mr. Fanshawe came back around 10 a.m. that morning, the doors were locked. Why were they locked?
Because we had the threat, and even though I wasn't allowed to go home at that time because I was working with the police, we didn't want any of the public to come in, or because we already were feeling unsafe, so we weren't going to let anybody else in the building. And plus, we didn't want to let anybody else in the building, and plus my boss had to go ahead and lock the door and stay for the time being.
Now, as the manager, did you also receive a string of emails regarding the employment with Mr. Fanshawe and MSU and their concerns?
I did.
And in receiving that, did you learn that Mr. Fanshawe was actually confronted by MSU over that weekend about their concerns?
I did.
That was prior to the voicemail being left?
Correct, and that's why Patrick made the termination this time.
Objection, Your Honor, speculation.
Objection is speculation. You want to respond to the objection?
I don't believe it's speculation. She's the manager. She's part of the. Yes, the.
Do you have personal knowledge about this, ma'am, that you're testifying to?
Yes.
Why do you think it's speculation?
You know, she said that's why Patrick decided to.
Well, she wouldn't have personal knowledge about why she can't testify to what Patrick decided.
I didn't say decide.
Well, you can't testify to what Patrick did unless you have personal knowledge or you all had a discussion about it.
I do based on what the owner of the company told us to do.
So
Okay, so this is not speculation. So
matters in the.
objection to speculation is overruled. Is there another objection?
No, Your Honor.
Okay.
In the course of your employment, you and Patrick were instructed to do something?
Yes, so because it was a threatening thing and he had been aggressive with MSU and the other staff there already, and I had a little bit of an issue that he was personal history, that they let Patrick go ahead and do this. Usually that is my job.
And as far as when the call came in, that was logged on your phone, is that
Correct.
Okay. When you initially called police, was it calling a 911 number?
I think I did call the 911. I cannot recall.
And when police responded, is that when you identified who the caller was?
Yes,
The first time that you came face to face with an officer to report this, you were able to identify who the
Yes.
caller was. Thank you.
It's going to be excused.
Yes.
Okay, thank
You
you.
know, just a follow-up regarding the question on the area code of the phone or the private phone. When I just want to put some clarification.
You want clarification as to the area code of the private phone?
No, I have clarification as to when you have a private phone coming to your system, how does that phone look like? How does it look on?
it shows up as a 2 with a series of 6s.
Okay. How many sixes?
I do not recall.
Are you aware that 266 is a country code for Lesotho?
You said for what?
Lesotho, it's a country area, a country code for
Oh,
Lesotho.
Okay, can you redirect based on that?
The number that you saw come across, that's consistent with numbers that come across your phone as private calls.
Correct,
So it's based off your internet phone provider,
correct, as far as I know.
not something that you input into the phone.
No, correct.
Thank you.
Okay, thank you, ma'am. You may be excused. Thank you. You can call your next witness.
Keep a restaurant.
Is the defense calling witnesses?
No.
Okay, argument.
Thank you, Your Honor, based on the testimony today, Mr. Vino testified that Mr. Fanchen was employed by Pro Employment Agency at the Kellogg Center at MSU, and that during the course of that employment, it was decided that he would be terminated from employment. The reason for that termination was that he was being aggressive while at work, that he was agitated and was scaring MSU employees. That when Ms. Trevino came into work that day, she received a phone call or a voicemail, I apologize. In that voicemail, there was multiple threats to shoot you all, to specifically target the white woman manager, and that, again, repeated contact or repeated threats to shoot you all throughout that voicemail. That voicemail was about a minute and a half long. Receiving that voicemail, that threat to shoot, made Ms. Trevino feel like the threat was to kill her or kill her fellow employees or anybody else that would be in the business at that time. And they ended up locking the door actually while they were reporting things to police. They needed to report to police and gave police the phone call, voicemail, and then a separate recorded call that an additional manager had made with Mr. Fanchen. Based on that evidence, Your Honor, and the threat that was made to shoot you all, again, I think one can reasonably assume that that means to at least attempt to murder, if not murder those that were in there in that business, but that would be a reasonable fear to have when somebody who you know has a history of being aggressive and agitated, has just been terminated from their employment and is leaving a threat at that employment agency, and that the defendant would know that that would be a reasonable likelihood that would frighten somebody with asking violence over the charge of complaint.
Just want you.
Thank you. The timeline is very important here. Mr. Vino first of all testified, she first testified that my client already knew that he was being terminated, which is not true. The phone call came at 7:45, 38.
The phone call in question?
The threat, the
Okay, thank you.
voicemail came, threatening voicemail came at 7:30. A client would call at 10:35
On the same day?
on the same day to tell on the 25th. He was told that there was some problem in his background and that his employment was suspended. There was no threat. He did not say anything. I was just surprised. There was no testimony here that my client has ever been told that MSU had any concern about his behavior. He was told that there was something that came up in his background that required that his case be suspended, that his employment with MSU be suspended. It goes to motive. What was the point for him? He didn't know that he was being terminated. What's the point for him to call in the morning to start taking in people? The other thing is that he came and he did not have a gun. He did not have any, there was no testimony that when he had any encounter later on with Pat and even signed his paperwork that he was acting in a threatening manner. He did not threaten anyone, he did not had a gun, he left and the police was there, the police arrested him. That's the only thing that my client knows about this matter. There is testimony that it was private, that the phone call came. There was no testimony that the phone call came from my client. Yes, there was testimony that the phone call showed that it was private, but again, this is what was the motive? Why would my client call at 7 in the morning when he knows, and again, he knows that he's still employed. My client, when Pat asked him, I don't want you to go to MSU. He said, yeah, I'm not going to go to MSU. I wasn't even scheduled to work today. So I don't think that there was any reasonable, that there is any evidence, even with probable cause, that this client is the one who made those phone calls. And so I asked the court not to hand over the case.
I guess first I will start with that any conversation that Mr. Fanchen had with this cat character, or anything that's in the context of that is not in evidence. That phone call was not admitted in evidence. So any assumption made from that call cannot be used. Additionally, Your Honor, that Mr. Vito did testify that Mr. Fanchen was the only employee that she had at that point with any type of accent, and that she did come to know him, and did come to know his accent and his voice in general. And was able to not only see him when he walked into a place, but also identify his voice on the phone. Regarding the number and the area code or the private number, Your Honor, Ms. Trevino testified that the number that came across her screen and the format that it came across is consistent with when somebody calls their agency and they have blocked their number. It's a private number that will go to the defendant's intent in this case. And finally, Your Honor, Ms. Trevino did testify that she had received a string of emails that over the weekend when Mr. Fanchen was working at MSU, that the employees at the Kellogg Center did confront him about his aggressive nature, letting him know that he would not be invited back to the Kellogg Center. So regardless of when Pat made the call, which again, that is not in evidence either as to what date or time that happened at, it's not admitted.
Right, but although that was not in evidence, there was, I think, someone impeaching your witness's time frame as to when he was called. She said a couple days prior to this voicemail.
She said he had been informed a couple of days, and then there was still, I'm still unclear as to.
She said he was terminated.
Yes.
Yeah, that's what she said, and then that wouldn't be the case after this other phone call. Refresh your recollection.
Except if the Kellogg Center had informed Mr. Fanchen that he would not be invited back, and that due to his aggressive nature, which she did.
We don't know
testify to
that.
She did testify to that, right? That she had been contacted, she had received that string of emails that had detailed how she knew what the complaints were at MSU, that they had confronted the defendant at that time, that he was aggressively did so. So that information, Your Honor, coupled with the fact that, again, she was able to recognize his voice, that he had been terminated from MSU, that he had conflict at least with the Kellogg Center, which actually the money.
She said she can recognize his voice most of the time, not all the time.
Let me
Also what?
let me add just something, just. Right. MSU, the people who employ my client are the staffing agency.
Correct,
It's not MSU.
correct.
Thank you.
Okay, can I hear the video? I'm gonna listen to it from your phone because I did not realize that it was video and that it had his personal protected information on it. So his social security card is on there and I think his ID. So that should not have been published in open court. It's volume up.
Oh, actually, it's probably muted, John.
Thank you. Today was the date set for preliminary examination. The burden is on the prosecution to establish that they have sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need to show that they have more than mere suspicion that a crime was committed. The court is the sole determiner of the credibility of the witnesses. In this case, we had one witness. And the court will also weigh the likelihood of the prosecution's success at trial. So again, we had one witness, Daniela Trevino, and that Danielle Trevino, that is, she testified that on the date of March 25th, 2024, she was employed at a staffing agency that was located at 300 North Clifford Street, City of Lansing, Ingham County, State of Michigan. That makes venue in this court appropriate. She testified that while employed at Spirion Staffing Agency, she was in the position of a manager, and that she was familiar with the person she identified as in the court today as a defined quantum. She said that he was someone that looked for work frequently through their staffing agency, and that she would be able to recognize him, or most of the time she could recognize his voice. She stated that on that date and time in question that she would check the voicemails at work, and that there had been a voicemail that had come in prior to her coming to work that day, that she listened to the voicemail a few times to try to understand what was being said, and ascertained there to be some threats being made. She said the threats kind of scared her because the person in the voicemail kept referring to the manager, and she was a manager. That the person said that they would shoot up the place. Witness testified that the defendant was someone who they had previously, or at the time contemporaneous to this, had employed at the Kellogg Center in the food service until she believed that day, or maybe 2 days prior, his assignment having been terminated after receiving some information from the Kellogg Center about complaints about aggressive nature or behavior by the defendant. The defendant is now being charged with false report or threat of terrorism, and to prove that at trial, the prosecution would need to prove first that the defendant communicated with either speech, well, in this case, communicated with the parties in this case, the Spirion Staffing Agency, by speech, writing, gestures, or conduct. Second, that during the course of the communication, the defendant threatened to commit an act of terrorism. A threat does not have to be stated in any particular terms, but must express a warning of danger or harm. Further, it must have been a true threat and not have been something like idle talk or a statement made in jest or a political comment. It must have been made under circumstances where a reasonable person would think that others may take the threat seriously as expressing an intent to inflict harm or damage. To prove that the defendant threatened to commit an act of terrorism, the prosecutor must prove that the defendant communicated that he would commit, in this case, the felony crime of felonious assault, that the defendant knew or had reason to know that committing the felony would be dangerous to life, human life, meaning that committing the felony would cause substantial likelihood of death or serious injury, or the felony involved kidnapping, and that by committing the felony, the defendant would intend to intimidate, frighten, or coerce a civilian population, or influence or affect the conduct of government or a unit of government through intimidation or coercion. It does not matter whether the defendant actually could commit the felony or actually intended to commit the felony, or whether the defendant threatened to commit the felony as an act of terrorism. I heard the video or the audio to the video twice. I understand that the circumstances here all need to be considered as a whole, taken together. We have a staffing agency that receives a voicemail where someone who's familiar with how the defendant carries himself, how he speaks and how he looks, but particularly with his voice and his accent, he gets a voicemail. And that voicemail is threatening in nature, threatening to shoot up them, shoot all of them, or shoot up the place, or whatever it was said on the video or audio. And that at the same time, or contemporaneous to that, the staffing agency is fielding a issue involving terminating someone from employment that they had placed them at a place that recently suffered from a mass shooting, and that the reason why the termination is taking place is due to aggressive nature. And then I've heard the statements, I found that those statements would be taken alone would be threatening. The question of fact is whether or not those are statements that are made by this defendant sitting here in court. We don't have a phone number. It was called maybe from a block number or a private number. And witness testified that when they get phone numbers or phone calls from a private number, there's a specific number that has a series of sixes, two and a series of sixes that show up. So they weren't able to identify. So all we're basing this off of is a totality of the circumstances involving the termination from the Kellogg in close proximity to the voicemail, the thick accent, the statements that are being made, and then this witness's testimony that she is able to recognize this defendant's voice. I heard the voice. I've heard the defendant multiple times because he doesn't know how to be quiet in court. It sounds a lot like him to me too. Based on the information provided to the court is satisfied that there's sufficient probable cause as to count one that will be bound over to the circuit court for further prosecution. Find over date is going to be July 3rd. That's the date the circuit court gets the file from the district court. Once they receive the file, you do not need to appear in court on that date unless Ms. Wanji is filing a motion for you to be rearranged in circuit court. Otherwise, your next court appearance will be a pre-trial in circuit court, okay? Bond was set at 75,000 cash to surety. That will continue. Any additional matters for the record?
Then I would like to address bond. I think that the court had requested previously that my client be evaluated by CATS. And there was a report from CATS that found that my client was not, that came out that he was quite harmed, that he was not posing any danger to anyone at the jail. And I think that also considering the facts of this case, and I know there is a probable cause that was the burden of the prosecutor at this level, but considering the fact that I don't think that if we continue this way, that my client will be able to, the prosecutor will be able to show by reasonable doubt that my client committed this crime. And he's been in jail, and I believe that if there were some conditions put in place so that he can follow through with the no contact with the face and that he report to legal services. There is no question about substance abuse in this case. He is a US citizen, so there is no flight risk. I understand that he wants to stay here in Michigan, and he has to stay here in Michigan in order to finish up with this case. So for all this reason, although he had not been, he had lived in Michigan for quite some time, not for his whole life, but he has some ties here in the community. So we would respectfully ask that the bond be reduced to an amount that he can pay. At this time, so 75,000, it's very high, and considering the fact that he's indigent, it amounts at no bond for his case, Your Honor. So we will respect to ask that the bond be reduced to a certain amount that he can pay, including PR bond.
Did the prosecution want to respond?
Thank you, Your Honor. Your Honor, the allegations in this case are obviously quite severe. However, and I apologize, Your Honor, I don't have the bond report in front of me, but I do have notes in our file from that bond report. And the notes in my file indicate that the defendant actually threatened to shoot up the officers and the person conducting the bond interview as well. So with all due respect to Ms. Wanji, it appears that this defendant not only has an aggressive nature, but that he is not afraid to threaten others with physical harm, including shooting them. This defendant during the preliminary examination was laughing, was smiling, was essentially making it appear that he did not take his case seriously. And given that, plus the additional threats that he made to pretrial services, knowing they were doing a bond report, I would ask this court leave bond the same, as he is very clearly a risk to society.
I have the bond report here in the file. And it was the magistrate who ordered the CAT's evaluation when she did the arraignment. And the bond report does indicate a concern about his threat to the public safety. It states that the defendant has a multi-state criminal record with criminal contacts in Georgia and Ohio. Per the police report, the defendant was arrested after law enforcement was called due to the defendant making threats against the Kellogg Center and employees. It should be noted that at the end of the reporting, investigators interviewed the defendant, became very agitated, it says extremely agitated actually, and started yelling that he would shoot the police officer. He yelled this multiple times. Upon leaving LPD reporting, investigator advised the LPD detention employees of what the defendant stated. It stated here that due to the pretrial risk assessment, it identified substantial risks as average for his assessment score based on violent felony offense charge, with recommending that he do not be released upon his own recognizance. And so PR bond was not granted. You're asking now to reduce the bond so that he can, it could be a bond that he can post. I think that based on the allegations and even based on the information in the sentence or pre-trial release report, the court does have some concerns about the public safety, because if true, this is an individual that had no concerns about making threats to shoot law enforcement, then the public doesn't have a chance. So I think 75,000 is a high bond, but it's to secure the safety of the public, and I think it's appropriate. And so your bond motion is denied. A bond is continued as said. Any additional matters for the record?
Nothing to keep, Your Honor. Thank you.
Nothing for the defense, Your Honor.
You're all set.
Thank you. My name.
Who's in the jail?
Joseph Wahadlo, Your Honor.
That's my case, Your Honor.
On the iPhone? What's your name, sir?
Chauncey Mendenhall.
Okay. a second case.
Thank you.
Yeah.
Mr. Ferguson, you represent Chauncey Mendenhall?
I do, Your Honor.
Okay. Mr. Mendenhall, I can't see you.
My bad.
Are you ready for Wahaldo too?
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Joseph Michael Wahaldo, file number 24-01738, council appearance.
Good afternoon, Your Honor. Natalie Meekum, on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. Waddle, who's present by way of Polycom from the Eagan County Jail this afternoon, Your Honor.
Okay, today's the date that was set for a probable cause conference. I have an assault. It's intent to do great bodily harm, a domestic violence third, and interfering with electronic communication. This matter is scheduled for preliminary examination June 28th at 8:30 in the morning in person at the court. Are we continuing to examine?
Yes, we are, Your Honor. I know there's been an offer conveyed to me just this today from Assistant Prosecutor, Ms. May Cumber. I need a chance to speak to my client about that, but for now, we wish to leave the matter on for him.
Okay, so we'll see you next week, Mr. Wahaldo, in court at 8:30 in the morning. If you have any questions?
I just asked that, possible PR bond, please.
Your bond is denied. Any additional matters for the record?
None, Your Honor. Thank you.
Okay.
You're all set. Thank you. Thank you, sir.
All right, thank you.
Sir, I'll be out to meet with you next week. We'll chat next week.
Okay, on the record, in the matter of the people of the state of Michigan versus Chauncey Mendenhall, file number 24-01594, council appearance.
Good afternoon, Your Honor. Natalie Meekum, on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Chauncey Mendenhall, who's present by way of video conferencing this morning, Your Honor, this afternoon, excuse me.
Okay, now, Mr. Mendenhall, you have a probable cause conference in this matter. I have assault with intent to do great bodily harm, less than murder or by strangulation, and a domestic violence, and there's an habitual offender fourth offense notice. You're scheduled for a preliminary examination in this court, June 28th at 8:30 in the morning in person. Are we continuing to examine?
I believe we are, Your Honor. There's been a Ms. Maycumber conveyed to me an offer of a misdemeanor domestic violence, Your Honor. I'd like to leave the matter on for an exam, and we can discuss our options going forward this week.
Okay, Mr. Mendenhall, do you have any questions?
No, ma'am.
Okay, well then we'll see you next week, in person on that matter. File number 23L278786A, Mr. Mendenhall is City of Lansing versus Mendenhall. And you have a warrant on that because you owe some money and you didn't appear for the show cause. You owe $132.
Yeah, they just told me about that on the phone. I didn't even know that I had court, ma'am.
Okay, when are you gonna pay it?
You said, when am I going to pay it?
Correct.
I'm about to just come down there today and pay it.
Note here that you're gonna come pay today, okay?
You said what, ma'am?
Note here that you're gonna come pay today so the warrant can be cleared once you pay it, okay?
Okay, I'll be there in a few minutes.
You're all set.
All right, thank you.
Thank you. Mr. Rojaldo, you need to let the deputy know that you're all set.
All right, thank you.
You're welcome. Ms. Donnelly. Raina Guerra is present.
He is. I was wondering if the translator had muted.
Oh, I'm not seeing a translator yet. And Shaquila right here.
I am.
Okay, someone filling in for Milks, or is Milks coming? Mr.
Hello,
Milks,
Your
he
Honor.
knows that I can't see behind this computer.
Ah,
Yes, I do.
Okay, wonderful. On the record, in the matter of the people of the state of Michigan, Register Trailer Right, file number 22-02337, council appearance.
Good afternoon, Your Honor, Natalie Maycomber on behalf of the people.
And good afternoon, Your Honor, Stephen Wilson, Apple's right, present stage to my right.
Okay, we reset this matter because there was supposed to be some diversion.
Your Honor, I believe we are going to do the diversion as we had discussed. I think today we've just had on schedule just to make sure that we didn't lose sight of the case.
Correct.
I just can't remember if it is my client who's supposed to reach out or if it's the prosecutor's office supposed to reach out. So I guess it's a good time for Ms. Maycomber to talk a little bit.
Sounds good.
Thank you, Your Honor.
So obviously diversion is not happening yet, so you're gonna talk and then you're gonna need another date to make sure this doesn't get lost.
Your Honor, I believe knock on wood, that we would be able to figure this out by the end of the day today.
Okay,
So we can leave it on for next week. That's not.
it's not set for next week, that's why I'm asking. I only set it for a PCC, so I can set it for another date.
We can set whenever your next available date is. Hopefully we'll
I'll set for
have a,
another PCC next week.
Thank
okay.
you.
Thank you, Your Honor.
June 27th at 8:30. No interpreter.
Oh, Carlos. Carlos said if we need.
Oh, okay. We gotta, we can get the security officer to be your interpreter.
I'll get Carlos.
Sounds
radio.
Okay. She's gonna radio.
1:30.
On the record, in the matter of the people of the state of Michigan versus Kale Adams, file number 24-00160. Parents for the record.
Good afternoon, Your Honor, Natalie Maycomber on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Stephen Weigels on behalf of Miss Adams, who's standing to my right today, Your Honor.
This is my docket sheet for today. First name, 8:30. Yours. Are you here at 1:40?
Because my ride didn't show up and I had the kids and my mom, that's the phone I used, so when he was calling her, I wasn't with her. So I just had to come basically when I had a ride.
So you knew what time you had court?
No, I really forgot.
Why
But I
did you
had court today.
Why did you forget you had court today?
Because when y'all rescheduled it from the, I think it was the 13th to another day, I thought it was tomorrow.
Rescheduled?
Yeah, because remember my lawyer didn't show up, so I
You didn't
just got.
reschedule, you didn't reschedule you. You did not have an attorney, a new intake had to happen, so we gave you paperwork. It told you what day you were supposed to appear for a probable cause conference, that was June 13th. It said that you appeared by Zoom before Judge Ward, because I was gone at a meeting. And you, when I gave you paperwork, it had today's date on it. I gave you that paperwork in May.
When I bought it out.
No, this date was changed because your first court date was for an exam was April 25th. When you appeared on the 17th, I found the cause to go beyond the 21 days because of scheduling. You appeared since then. You appeared via Zoom on April 18th before Judge Ward. She gave you a preliminary exam date for today. I saw you in between there because you didn't have an attorney, and I gave you what your options were so that you can do a new intake so that you can get an attorney. You now have an attorney. So you had this date since April. The date has not changed. June 21st was given to you in April. We gave it to you again in May. You appeared again last week before Judge Ward, but then you still didn't appear today. So I'm trying to understand, why aren't you keeping up with your court dates? Because listen, if somebody told me I'm facing 15 years, you think I'm not gonna remember? I'm gonna remember. I'm gonna get my butt to court.
Well, I do apologize. It won't happen again, but I don't have a phone and I didn't have a ride at work. So.
We have witnesses here.
And
Did we?
I'm not sure if we did or not.
Okay. So this matter is gonna be reset. It's your responsibility to keep up with your court dates. It's your responsibility to find a way to court. I don't care if you have to walk here. You got a felony pending. You gotta get to court. You can bring your kids if you have to, but you gotta get to court. Otherwise, I issue a warrant. And when I issue a warrant, when you fail to appear for a felony, I issue a remand. That means you're not getting a bond until I'm finished with you, because I'm not babysitting adults with their criminal matters. It's your responsibility to keep up with it, just like you would keep up with it for your hair appointment to get those braids that you got doing down your back. You better keep up with these court dates. Do you understand that?
Yes, ma'am.
I'm gonna get you a new date. I'm gonna quash the warrant. You need to appear. I don't know if you need to have somebody keep up with the date and remind you. I don't know, but you gotta get here because Mr. Price was very disappointed when he couldn't find you this morning. He was the first case I called, maybe the second, but you were the first on the list. And so we'll reset this. I don't know if witnesses were here because once we found out you weren't in the building, I issued a bench warrant. I didn't even call your case about after 10 o'clock because I was tied up until. So you could have even been late and you would have been fine, or reasonably late. Showing up after 12 o'clock, that's not late. That's not reasonably late. My staff hasn't had lunch 2 days in a row because we're trying to get these cases moved. And when people just show up late, you're abusing her time, his time, our time, and that's not fair. You understand that?
Yes, ma'am.
August 15th at 10:30. That's a notice to appear. Do you have any questions?
Nope.
Bond was set at 5,000, 10%. That will continue. Any additional matters for the record?
No, Your Honor, thank you.
Thank you.
You're all set, ma'am.
Thank you, Your Honor.
Thank you.
I'll make sure.
Thank you.
I'll make sure. Thank you.
No problem. Thank you, Jeff. Have a nice day.
Yeah.
It's after one, so let's get on here. Two rows of kids at the same time. Okay, let's see, Mr. Austin, you have someone in custody?
I do. AG, please.
Well, the AG is logging in now, but I don't have anybody from the jail on. Oh, we're early, that's why. Did you need to speak to the AG?
Wouldn't hurt if he's on there.
She.
It is, yep, she.
Ever know which one it's on?
Hi, Jared.
Okay, we'll have you log in and you can meet with her while we wait for them to put the defendant on.
Okay, sounds good.
Thank you, Judge.
Thank you.
Can you hear me in the courtroom?
Yes, we can hear you.
Okay,
Well,
Jared
I-
could not hear me. Jared, do you hear me now?
I can hear you
Oh, yeah.
now.
Okay. Can we
Do
try?
you want to go back
Yes,
breakout
please.
room?
Yes, please, Judge.
Yes, please.
I move you to room 2 and then
I'm still
put
trying
Austin
to
in
figure
room
out
2.
exactly what the dates were for the second.
Okay. Excuse me, miss. Can you hear me?
Are you talking to me?
Yes, ma'am. Are you here for Seabrook?
No, sir.
I was,
Mr. Seabrook,
on-
we are trying to figure out if you have an attorney or not. Just relax for a second and be quiet until the judge calls your case. She'll speak with
Yes,
you.
ma'am. Yes, ma'am, sorry.
You could be seated. Mr. Austin. Is he meeting? No, he's not meeting this time. Is that why Mr. Austin is? On the record, in the matter of the people of the state of Michigan versus Edisbell Arena Gira, file number 24-00943, council appearance.
Here's to your honor, Natalie Maycomber on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Isabel Reina Guerra, who is appearing to my right.
Okay, and we have an interpreter that is filling in for the court order interpreter that did not appear. Can you state your name for the record?
Carlos Hernandez.
Okay, raise your right hand. Do you solemnly swear or affirm that you interpret in the matter now before the court completely and accurately and not divulge confidential communication, so help you God?
I do.
Today was the date set for a probable cause conference. How are we proceeding?
Your Honor, if I may approach, I have a plea and advice.
Yes. Okay, so the offer is to plead guilty to an added count to a retail fraud second degree. And pay restitution. And the people will dismiss the remaining charges, correct?
Correct, Your Honor.
That's correct, Your Honor.
Want to plead guilty to retail fraud second? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, thank you. Okay, you understand that you have the right to the presumption of innocence? That means you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at a jury trial. You have the right to remain silent at your trial. You have the right to see, hear, or question any of the witnesses called to testify against you. You have the right to call your own witnesses to trial to testify on your behalf. You can waive your silence and testify at your trial if you like. But the silence cannot be used against you. You have the right to require them prove each element beyond a reasonable doubt. You want to give up all of those rights today? Anybody threatening you to give up your rights?
No. No.
Any promises being made in exchange for you entering a guilty plea today? Are you on probation? Which court?
Your Honor, he's on felony probation here in England County. But I have advised him, it's my understanding that this happened before he was put on probation.
You understand that a guilty plea could result in a conviction you need to report to your future employer. You also may have to report this conviction to a current employer.
Yes.
And it could have impact on travel or immigration status that you might see. Okay, as to the amended count 2 of retail fraud second, how do you plead?
Yes.
How do you plead, guilty or not guilty?
Yes.
You have to say it. Culpable or not, or no culpable.
Yes.
Factual basis.
Figure. Mr. Reina Guerra. Can ask you questions about the incident. On July 2nd, 2024, at the location of 350 Randor Avenue in the city of Lansing. Did you go into the Ulta Beauty store while it was open?
Yes.
And while it was open, did you assist or steal merchandise that was offered for sale at a price of about $881 or no, $811?
Y en ese tiempo usted entró a la tienda y ayudó con robar, que era $800. Yes.
And then did you return to the Ulta Beauty store while it was open to the public on July 17th?
Lo regresó 17 de julio.
And that would have been, I'm sorry, was I saying 2024? I apologize.
2023.
2023, so on July 17th of 2023, you returned to that Ulta Beauty store in the city of Lansing.
Lo regresó el 17 de julio 2023.
And while you were there and it was open, you stole property that was worth at that time an estimated $886.
Y en ese tiempo robó propiedad que era por ahí de $880. Yes.
And you don't dispute the amount in question was, so it was about $1,600.
Entonces en total usted diría que está derecho en decir que era como $1,600 en total.
No further questions.
Any questions from the prosecutor?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made.
Eso está bien con sus consejos de derecho y acepta lo que está diciendo.
Your sentencing is August 16th
16 de agosto,
at 9 a.m.
9 de la mañana. Va a regresar del 6 de agosto a las 9 de la mañana.
You need to meet with probation
Tiene que dar aprobación
so that they can provide the court with a report about how you should be sentenced.
para la aprobación, más para que puedan empezar el reporte, para que ellos lo puedan determinar pues ya se.
Do you have any questions today?
¿Tiene cualquier pregunta? No.
Okay, we'll get him down to probation right now. He's got to check in right now.
Yeah.
Any additional matters for the record?
Yeah, we have to go downstairs.
Thank you. Do we know where Mr. Austin went?
Cannon,
The
so
AG, you met with the AG and just left her hanging?
I'll go find him. I was waiting on McDermott to go on record with him, Your Honor, so when he appears,
Oh, okay. Seabrook is here. I don't believe he has an attorney.
I was looking on our system, I don't even see where we entered a felony for him yet.
Okay, he was arraigned on the 7th. He did request court appointed counsel, so.
Yes, I will, so.
He could use another intake.
Honestly, Your Honor, I don't think anything would have changed, so I will just submit a new application for
Okay.
him.
Okay, I'll note that here.
All right,
On the record in the matter of the people of the state of Michigan versus Carrie Seabrook, 24-01707 FY. I found the prosecutor's appearance.
Good afternoon, Your Honor. Madison May Cumber on behalf of the people.
Okay, Mr. Seabrook, today was a date set for probable cause conference. You did request court appointed counsel and you are represented by the public defender's office in other matters. But for some reason, you've not been appointed one on this matter. So the public defender was just in my courtroom. She's going to put your paperwork through so that you can get representation. We're gonna treat your court date next week as another probable cause conference, okay?
This is, I know it's not the right, I don't know how probably to answer this. Is there any way I could, have my bond reduced for PR so I can get back?
You
to
know
work?
what, what really is disturbing is when I'm talking to you about one thing and all you want to do is talk about what you want to talk about. What's the information I just gave you?
Yes, Your Honor, I agree with you, I'm sorry, I wasn't trying, I'm not trying to disrespect you in any way. I'm
Okay.
sorry, Your Honor,
Okay, what is the information I shared with you?
that I, do not have a lawyer as of this point right now, and that she is putting in the paperwork for me, and that my case is being adjourned until the next meeting, when I see you on Tuesday.
Thank you. Well, no, that's not till you see me on Tuesday. Tuesday, you're going to see me on a host of other matters. I have that before me. I was concerned about why I had someone on my docket that has, well, actually, I'm gonna see you on Monday, it looks like, for your
Yes,
failure to
yes.
display ops. And then I'm gonna see you on Tuesday on 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 cases.
Yes, ma'am.
You still want to talk to me about your bond?
Yes, I would like to be able to pay you when I see you on both those days. I need to be able to get back to work. But I mean, I'm not trying to upset you, Your Honor. I'm
not upset. I am not upset.
I just, my house got broken into, they took my dogs are gone, I'm not even allowed to be in my house, but I need to go by your door to, so I can have somebody who put it on. My girl and my daughter are sitting in the house with no protection, someone's already running in my house. And I'm sitting here, I have no way of being able to.
How do you know that someone's in your house if you're in jail?
Because my mother still talks to my daughter and my daughter doesn't feel safe at home.
But no one can go secure your property?
I need to get out so I can provide the money so that I can.
Well, all they have to do is lock the door. Why wouldn't they be able to secure it for you?
Say again, Your Honor?
Why would they not be able to secure the property by locking the door?
Because they kicked the door in and broke the lock.
Oh, well, your bond was set at 3,010%. I don't know what his bonds are. The other matters are not serious matters, but I don't think that you are a person that typically comes to court. Let me double check your bond.
I always come to court, Your Honor.
Let me check the bond report.
Sorry, Your Honor.
Average of 5, let's see. Doesn't say that he's got more than 2 qualifying failure to appear, so.
Your Honor, if I may.
That's police and reconnaissance not recommended. And it was out on bond with defense. Says defendant was out on bond at the time that this alleged offense was committed, so you would not be eligible for non-financial release due to 765.6A. Your bond is only set at 3,010%, so you just gotta pay $300 to get out, sir.
All my money went towards my business, which I just started, and my mother's money went towards me in the hospital 2 months ago.
I'm sorry to hear that, sir. But that's your bond and I'm not amending it. Any additional matters for today's record?
Nothing from the people, Your Honor.
You're all set.
Thank you, Your Honor.
You're welcome.
I'll see you on Monday.
And Tuesday.
And Tuesday, ma'am. Sorry.
No problem. And
Have a good day.
and Friday. I'll see you 3 days next week.
Look forward to it. Have a good day, Your Honor.
Wonderful. We need to see what's going on with the AG case. Treat next week is PCC.
It's my understanding the case is going to be waived, Judge.
Oh, okay. Well, I think they're probably gonna put his client on next because.
Okay, thank you.
No, this is Cowling. Okay, Ms. Gable. You're muted. And I
Good
see.
afternoon, Your Honor.
Good afternoon. Okay, you're here on behalf of Service Link Technology versus True Tech Solutions.
Yes,
Okay, I don't know who's supposed to be here for True Tech. Mr. Travis Truthman, are you a representative of True Tech Solutions?
Yes, I am.
Okay, where's your attorney? Do you have an attorney?
I do not. I can't afford one right now.
Okay, well, this is a discovery matter. I'll put you in a private meeting room with Ms. Gable so that you can do your examination with her, okay?
Okay.
You have you raise your right hand. Do you solemnly swear or affirm that you'll answer the questions posed to you truthfully and accurately under the penalty of perjury?
I do.
Thank you. I'll put you in a private meeting room.
Your Honor, before we go into a breakout room, there was one preliminary matter I would like to put on the record just to do that for efficiency reasons. For the subpoena, I requested several documents, including tax returns, bank statements, everything that I would be entitled to pursuant to this debtor's exam. Mr. Trufant, on behalf of his company, has failed to produce a single document to me. So to the extent, I'm willing to give him some grace and, offer a 7-day extension on that. But if those aren't received, I would ask that either we continue the debtor's exam for a week from today or when the alternative request a bench warrant.
Okay, we weren't actually on the record because I didn't call the case. I was just swearing him in. And so I'm gonna let you, but he's heard all of that. And to the extent that we need to officially put that on the record, we'll do that after you meet with him in the private meeting room. We might need to, maybe we need to move forward with the show cause at this point instead of setting it for discovery. Because if he hasn't provided that information, we don't need to just keep setting it out, but we'll let you deal with that in the private meeting room. And then we'll see how it needs to be resolved. I just gotta finish up some other criminal matters in the interim.
Okay, thank you.
No problem. Okay, this is Mr. McDermott.
Yes.
Of course, they didn't put Cowan. Where's Cowan? Did they put Cowan up? They have more than one polygon. They haven't put him on yet.
Yeah, he's in post one. I do know that.
Post one. Yeah, I don't know why they didn't put him on yet. Okay, let's see. LVNV Funding LLC. Who's representing them?
Good afternoon, Your Honor. Oh. I was going to say, because I'm also here. Which defendant?
Well, what's your
I'm
file
here
number?
for. Let's see. Mine ends in 760.
760. Okay, so you're here on the matter against Cade, correct?
Correct.
Okay, is anybody here for Edward Cade? You're Edward Cade, very good, okay. So this is a pre-trial, so I need to get you in a private meeting room so that you all can discuss either resolution or a joint pre-trial statement. Counsel will prepare that using the court's pre-trial statement form and file that with the court electronically. Do you have a device that you can get on Zoom with?
Not sure, I'm not that very good at Zoom, but if I need an attorney for this, maybe I should,
There's a lot of things. I asked you, did you have a device that you can get on Zoom with? I didn't ask you if you were good with Zoom. You have a cell phone with you?
I have a cell phone, yes.
Okay, so you were shaking your head, but the answer is yes, I do have a device that I can get on Zoom with, because we have someone that can help you get on Zoom. I just need to know if you have a device.
I have a device.
Okay, very good. So when my court officer returns, we'll get you on Zoom so that you can meet privately with Mr. Katz and then see if you can either resolve it or see if you can. If you can't, we'll come up with some dates, and you have the right to get an attorney and hire one if that's what you want to do. But that's not gonna stop today's process, okay? If you do hire an attorney, they'll file their appearance, and if they need another pretrial, they'll notice the court, okay?
Yes, sir.
Okay. So you hang tight, we'll get you in a private meeting room.
Thank you.
Thank you. And then, Mr. Kirshenheiter, you're here on the other LVNV matter?
No, Judge, I'm here on Cavalry versus Denise Miller.
Oh, okay. Is Denise Miller present? Okay, Miss Miller, same question. Do you have a device that you can get on Zoom?
I do, ma'am.
Okay, we will get you on Zoom. Today's a pretrial, so the purpose is for you all to discuss some pretrial questions on our questionnaire so that we can file that, and that's how we get your scheduling order. That's how we tell you when discoveries due, when your next court date or where your trial is gonna be, or jury trial if you had demanded a jury trial, okay?
Okay.
And if you intend to hire an attorney, they will file an appearance, and if they need another pretrial, we'll set it for one after their request, okay?
Honor.
Can you do me a favor and get Ms. Miller and then Mr. Cade in private meeting rooms, separate rooms, of course, and get them on Zoom so that I can put them in the meeting room with the attorney. Anybody here for Michael Parisian? I don't see Michael Parisian. I do see Mr. Fay here for LVNV on that matter.
Yes, ma'am.
Okay.
Miller and Ms.
Denise Miller. You just get her on Zoom, and then Mr. Cade is present. On the record in the matter of LVNV Funding LLC versus Michael Parisian, file number 24-00222, council appearance.
Good afternoon, Your Honor. It's Craig Bay, P81401 on behalf of plaintiff.
Okay, today was the date and time set for a pre-trial in a general civil proceeding. The matter was scheduled for 2:30. It's currently 2:45. No one's appeared via Zoom or in the physical courtroom for Michael Parisian. Counsel, how did you want to proceed?
Just as a background, it looks like the matter was settled. He is working with a settlement company, payment to be made, but we just have not received the signed consent judgment back. So at this time, if we could request our office to submit a default judgment, and we can put the payment terms within the default judgment under the 7-day rule.
Okay, so the matter was settled and there was a payment, a signed payment order that was supposed to be completed?
Yeah, so we did mail out a consent judgment mid-May. We just haven't received that back. But the payments are on time. And they've been made monthly. It's just we haven't had the time, the consent judgment returned yet.
Okay, sounds good. So you're seeking a default and you'll put the terms of the judgment on that form, correct?
Will do, Your Honor.
Okay, and you can file that electronically through my file, and I'll review and sign it.
Perfect. Thank you, Your Honor. Have a good day.
Same to you. Okay, Mr. Cowling?
Yes, ma'am.
Okay. I don't know who's on the iPad though. Who's on Judge Simmons' courtroom iPad? Okay. On the record in the matter of the people of the state of Michigan versus Michael Cowling, file number 21-01915, counsel appearance.
Good afternoon, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Cowling. He is present with us today remotely from the Union County Jail. I am present in the courtroom.
Okay, today was the date that was scheduled for probable cause conference, and the matter is scheduled for preliminary examination June 28th at 9 a.m. My understanding, however, is that there is an unconditional waiver.
That is correct, Your Honor. Mr. Cowling, as well as the people, would be willing to waive their respective rights to a preliminary hearing, have the matter bound over as charged to the circuit court, and pursue negotiations at that point. And I would also like to be heard on bond if I may. Thank you.
Ms. Brenner, is that complete and accurate?
Yes, Your Honor, that's my understanding as well.
Okay, Mr. Cowling, you understand that you have the right to have a preliminary examination in the district court?
I do.
You understand that you have the right to require the prosecution put forth evidence at the preliminary examination that will establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime.
Yes, ma'am.
Are you willing or seeking to unconditionally waive your exam today?
I am.
Anybody threatening you to waive your right to examination?
No, ma'am.
Any promises being made to you if you waive your exam?
No, ma'am.
And you understand that the waiver is unconditional. You can't get to circuit court and decide that you don't like how negotiations are going and now you want your exam. Once you waive it, it's gone. You understand that, sir?
I do.
Your bind over date is July 3rd. And that's the date that the circuit court will get the file from the district court. You do not need to appear in court on that date unless your attorney files a motion for you to be rearranged in circuit court, okay?
Yes, ma'am.
Okay. And the bond was set at $6,213 cash only. You wanted to address bond?
Yes, if I may, Your Honor.
You can.
Thank you, Your Honor. This is a case where bond is set per statute at 25% of the arrears at the time the complaint was issued, which is why it is that figure. However, the court does have discretion to modify that bond on a showing of good cause. And a few things I would like to point out on behalf of Mr. Cowling that I believe would justify the court finding good cause to do so. One, he was working prior to being brought here and turning himself in on this matter. I've spoken with his employer and has confirmed that he is a self-employed tattoo artist and is living and working in Arizona. And he would have some money to put forth towards the bond, which of course would ultimately go towards the arrears. He just can't post that full amount. He would be able to post $1,000. He tells me, Your Honor. And also, I think it's significant to point out that Mr. Cowling did bring himself back here and avoid extradition and turn himself in. Now, for speaking with Ms. Brenner, this was something I was unaware of. It sounds like there was a process put in place that was going to end up bringing him back here, but Mr. Cowling ended up turning himself in and driving here from Arizona voluntarily and surrendered himself on this warrant. So I believe that that shows that he is someone that is taking this seriously and addressing this matter and would appear for any future court dates. Obviously, if he's working, that would be a good thing, so he could start making some progress towards making a dent towards the substantial arrears. And he obviously can't do that if he's in jail and can't post bond. I think there's been some ignorance on Mr. Collins' part as to how the process works, but I did confirm he did show me a copy of a letter where he had applied to the friend of the court to set up an account where he can start to make remote payments. They did send him a PIN number. They sent it to his last known address, which was a Michigan address. But nonetheless, that is another substantial step that he has taken, Your Honor, to show, I think, good faith that he wants to address this matter and will. And if he needs to come back in person for any future court dates, he is prepared to do that as well. So I would ask the court to find good cause and modify his bond to $1,000 cash.
Ms. Brenner.
Your Honor, I would object to that reduction. As the court's aware, the statute specifically states it should be set at 25% cash only. His arrearages have actually grown and over doubled since the time we issued this warrant. So now he owes just under $52,000. So if we go by that number, his bond should actually be increased to almost $13,000 cash. He has not ever made one penny of a payment through the front of the court towards his child support. And he has an ongoing obligation growing at $724 a month. He was fighting extradition and we were preparing a governor's warrant and he was arrested back in March. And so at the final date when the governor's warrant was about to be initiated where he was going to ride the bus back, he decided to drive back here. And that's good because he avoided the cost of extradition, but he didn't avoid the cost of all the work that goes in it behind the scenes for us to get the governor's warrant and then get our governor to send the warrant over to their governor. And so there was a lot of stuff that was going on in the process in the background because of his choices. So I would argue against it. I think he is not likely to return. There's no reason to let him out to pay when he wasn't paying, when he was out and working. And so I would ask that you leave the amount set per the statute.
Thank you. Again, the statute is what the statute is, and if the court were in a position to deviate that, the court would have to articulate that they have good cause to do that. And what you've stated here on the record, Mr. Austin, sounds good, but it doesn't amount to good cause. Again, that was my question once the prosecution took the record, is that this was a case that was issued in 2021. It's now 2024. And the balance then was over $24,000. So I knew that there had to be some additional arrearage unless your client was operating in good faith and making payments. And that was not a statement that came out of your mouth that he's making payments. He's not been making payments, and he was working, and he didn't voluntarily bring himself here. He was going to be extradited after this case has been pending. And I have reason to believe that he has knowledge that this has been pending even before the 2021 signing of the complaint and warrant. I think that he's a flight risk, and I don't think he has any interest in making payments voluntarily. And so the court thinks that the bond is more than appropriate. Bond could be increased to almost double that. But we'll leave it at what it is, $6,213 cash only. That will continue. Any additional matters for the record?
No, Your Honor, thank you.
That's just a couple if I brief, and I'm not arguing with the court. I just want to develop a more clear record on one thing, Your Honor. This was probably partially my fault because I know that people have stated that Mr. Collins has not voluntarily paid anything to a friend of the court on these arrears, and that is correct. I have seen some evidence that it appears that he may have been sending money directly to the custodial parent, which from speaking with Ms. Brenner, a motion could be filed with friend of the court and that could be applied towards his arrears. And I acknowledge that that's not official and it's below what he was being ordered to pay, but at least when he got back on his feet within the last couple of years, he was paying something. And additionally, Your Honor, I also have made Mr. Collins and Ms. Brenner aware of this. It would be my intention to contact the circuit court and to leave the arraignment date on so we can address Mr. Collins' case at that time. So once I secure what the official date is from the circuit court on that, I will notify the Attorney General's office so they can be sure to have someone present for that hearing.
Okay, so you're, just so I'm clear, you're intending to file a motion so he can be arraigned in circuit court?
Well, I think ultimately we're going to appear in circuit court and likely resolve the matter with a plea and readdress bond.
Got it. Okay, sounds good.
That's just a mechanism for us to speed up the process, so to speak.
Sounds good. So this bond over date's still July 3rd. If they want to give that date to you as the next court date, that'd be great. But the bond will continue as set. Any additional matters for today's record?
No, Your
I have
Honor.
nothing. Thank you.
Okay, you're all set, sir.
Thank you, Your Honor.
Thank you. Mr. Kirschenheiter?
Yes, Judge, hi. On that, I spoke with Ms. Miller and she has sent back a fraud packet to my office that we need to review. So I didn't know if the court wanted us to go through a pretrial order because we just need some time to review it.
She said she sent back what?
We had sent her a fraud packet. She's claiming fraud and it looks like it's quite possible. So we just, my client needs to.
We'll have her brought back into the courtroom and then I'll get you both a new date.
Perfect.
Can we bring her back and then whoever you put on my court?
Mr. Miller, I mean, Mr. Kate.
I was gonna say, he didn't know what to do, so now he's in there now, okay.
Yeah, I told him just hang tight, because he was speaking with Ms. Miller.
No, it's a different attorney for that one. Mr. Katz is here on that matter. 760, is that the? Yes.
Somebody else is here?
No, Mr. Katz was here for the one who's on the iPad, it's a different attorney. I just didn't know if whoever was on the iPad didn't know how to move the iPad into the court. Okay, Ms. Miller, can you hear me?
Yes, I can, ma'am.
Okay, so my understanding is that you recently submitted a fraud packet, so they need time to review it. So I'm going to reset this court date.
Okay.
Thanks, Judge.
July 24th at, you said what time? 8:30. 8:30.
Thanks, Judge.
Thank you, Ms. Miller. If you stop by the courtroom, we'll get you a notice to appear.
Have a great day.
Thank you very much, Judge.
Thank you. And Ms. Donnelly, Mr. McDermott is here.
Yes, I'm ready.
On the record in the matter of the people of the state of Michigan versus Lamont McDermott, file number 24-01757, council appearance.
Good afternoon, Your Honor, Natalie Maker.
Assistant Public Defender Sarah Donnelly on behalf of Defendant Lamont McDermott, who is appearing separately from the Union County Jail.
Okay, today was the date Mr. McDermott set for a probable cause conference in this matter scheduled for a preliminary examination next week, June 28th at 9 o'clock in the morning in person at the court. How are we proceeding?
Your Honor, at this time, we would be continuing on to the preliminary exam next week. There is an offer from the state I received from APA Trotsky in regards to disorderly jostling with fines and costs, but we'll consider that in the meantime. I did want to make a bond request. Thank you, Your Honor. Mr. McDermott's current was set at 7,500 cash surety when he was arraigned on the 12th. He's been in custody since then. So he has, I believe, 11 days custody. I think the major concern at arraignment was that the only thing I can guess was because this is it's resisting instruction, but there's no reports of any injury. He lives in Lansing. He did have a case out in Mason that he has a bond for as well. But I think the big issue is that I think there's a hold in St. Clair County, and I think it's a child support issue. I don't know if it's with, I think it's with the friend of the court, not with I don't think he's been charged with anything, but yes, he owes, it says that here's quite a amount of money to St. Clair County, but I'm not exactly sure if if he's gonna get picked up on that or not. My only concern, Your Honor, is, the nature of the allegations is, I don't believe that Mr. McDermott is a flight risk or a danger. And obviously he's sitting in jail, on this, awaiting for his exam. So I didn't know if the court would consider, amending or reducing his bond. Thank you.
Did the prosecution want to respond to the motion?
Yes, Your Honor, Your Honor, I ask that you leave bond as is, and while this case cannot result in any sort of injury, this is a case in which officers were investigating a shooting. And this defendant not only interfered with that investigation, but then also kind of went hands-on and pushing officers and slapping their arms away as they're trying to separate him from the witnesses that they were trying to speak to. Officers that, again, were investigating this crime in full uniform with the defendant knowing that they were in uniform. Obviously, those are the allegations in this case. I would also point out that Mr. Mendenhall does have a pending misdemeanor assault and battery file as well. So I would say that the court could find that he does have an aggressive history, or at least have a assaultive history. Based on that, he does have a prior attempt RNO. Admittedly, it was very long ago. However, Your Honor, with those traditions, or I'm sorry, with those factors in place, we got to move on as is.
I think a 75 is probably the highest I've seen a bond for a police officer assault without an injury. That's being offered to disorderly jostling. So egregious, and I don't see how the offer goes to disorderly jostling and holds him a 7,500 cash surety bond. If he fled today, I certainly wouldn't have been holding him on a 7,500 cash surety bond pending sentencing. I don't see where he met with pretrial services for them to complete the bond recommendation. My record reflects that he refused to do that, but that he didn't have 2 or more qualifying failure to appears. I don't think that 7,500 cash surety bond is necessary for him to bond to a PR bond. 7,500 personal recognizance. You need to appear in court in person next week, sir, okay?
Yes, ma'am.
Do you have any questions?
Yeah, for my attorney, the plea bargain that was offered to me, I didn't really get to discuss any of that with her, and I was wondering.
You want me to put you in a private meeting room?
Yes, please.
Okay. Off the record. Can I see this person? Is this person on my docket today?
Yeah.
Oh.
Notes.
Oh, okay, they took care of it, got it. Okay, I'll put you in a private meeting room, and there you go.
Thank you, Your Honor.
Thank you, I think that was the last criminal one we had today. It's the last file, and if not, and I'm just waiting for. I'm just waiting for the person in courtroom 4, room 4.
He had a whole lot of different counties.
It wasn't on the report.
Yeah, oh yeah, let me grab my pen. I think I dropped it on the ground here. Come on now. Okay, when you have a fake shoulder, you can't use it like a normal one. Thank you.
You're welcome.
Okay, let's see, Mr. Katz, did you and Mr. K come to resolution or a joint pretrial statement?
Your Honor, we're going to enter the pretrial statement. Basically, we're asking for 60 days of discovery, and hopefully this will get resolved, but the plaintiff may have to file a motion for summary, but outside of that.
Okay, do you have our court pretrial statement for him? Because I need I need you all to complete the questions on there. That's how we don't just set discovery deadlines. We do an entire pretrial form, and then we'll give you the discovery deadlines as well as motion deadlines and a date for your trial based on that form. So I can email you the form if you need it.
Yeah, I'm gonna need that form.
What's your email?
Andrew at silversteinlegal.com.
Can you spell that?
SILVERSTEINLEGAL.
Okay, can you say that again?
SILVERSTEINLEGAL.
I think the issue is it's a little muffled, so we don't know if you're saying F or S. So
F
can
as
you?
in snake.
In chat. That didn't even help. Can you type it in the chat, please? Okay, Ms. Gable is back with Mr. Trufant as well. Let's see. On the record in the matter of Service Link Technology versus True Tech Solutions 23-02826 GC. Council appearance.
Catherine Gable, P 81555 on behalf of plaintiff.
Okay, Mr. Trufant is present via Zoom without counsel, and the parties met privately. Ms. Gable, you did put some information before the court prior to us going on the record about information that was required or requested from Mr. Trufant that he's not tendered to you.
Yes, Your Honor, I requested tax documentation from 2021 through present, along with certain financial documentation, bank statements, personal or financial statements, things of that sort, and various other things that were attached as Exhibit A to the subpoena. I have yet to receive a single document, so I would request that this is set for a show cause. And I'm happy to give Mr. Trufant and his company 14 days to produce that documentation to me, which can be sent via email, no problem.
Okay, Mr. Trufant, why have you not tendered that information?
Sorry, I had it muted. We've been working out the papers and stuff like that I was never officially served in person. So a lot of that stuff I did not have. But she just gave me the list. We just went through all the list of everything that we need to produce. So I'm gonna get those emailed over to her. She's emailing me a list of everything that we need, and then I'm gonna email everything back to her that she requested.
Okay, so we'll set this matter for a show cause. Hopefully this will be resolved prior to that time. And then we won't have to proceed with the show cause hearing. Is that? Show cause hearing? Oh. For at least 14 days. July 8th. July 8th at 2 work for you, Ms. Gable?
Yes, Your Honor, thank you.
Okay, we'll convene July 8th at 2 unless we get notice that you're satisfied and you need to call off the show cause, okay?
Yep, thank you so much.
2 o'clock?
Thank you. 2 p.m., that's correct.
2 p.m. All right.
Thank you.
Thank
Have
you.
a good weekend.
You too.
Thank you. Okay, and Mr. Katz, did you get our email?
I did receive it, Your Honor.
Okay, do you want us to put the defendant back on in the room for you all to complete that?
Yeah, we're gonna have to.
Okay, you can put him back on Zoom, please. You're in room one.